Hi, welcome everyone. This is another video of the Maxim game. In the prior video, we learnt about absoluta sententia expositor non indigit, which means that a plain and simple proposition in law requires no explanation. We learnt about the applicability of this maxim in the various rules of interpretation and also the exceptions thereof. Prior to that, we have dealt with the maxim acta exteriora indicant interiora secreta, which means that act itself indicates the intention. Now, in this video, we will learn about the maxim actio non datur non damnificata, the applicability of the maxim, and exceptions thereof, if any, with respect to the maxim. The maxim actio non datur non damnificata is derived from Latin phraseology. It means in plain English that an action is not given to one who is not injured. The right to action is always given to one who is aggrieved, who is injured, whose rights are infringed, and this right of action is given to that person, the aggrieved person, against the wrongdoer. Now we will learn about the applicability of the maxim. The maxim actio non datur non damnificata is used in a general parlance. It is applicable upon all those laws which creates the substantive right to sue. Therefore, any law which is of substantive nature finds the applicability of this maxim, and however, in certain cases, the procedural laws also sometimes calls for the applicability of this maxim, actio non datur non damnificata, which means that no right of action arises to the person who is not aggrieved. The law of contracts is another law of substantive nature which creates certain rights upon the parties. In India, we have several branches of the laws of contract in the form of the Partnership Act, in the form of Negotiable Instruments Act, in the form of Sale of Goods Act, etc. The Indian Contract Act 1872, being substantive law, creates an obligation on the parties to perform the contract as per the terms and conditions of the contract. This has been laid down under Section 37 of the Indian Contract Act. The entire law of contract 1872 calls for formation of contract, different kinds of contract, and deals with the consequences of breach of contract. It also provides for the remedy with respect to breach of contract. A contract is said to be breached when the conditions of the contract are not performed as per the terms and conditions of the contract, or by any other means which leads the contract itself to not come into happening. When the contract is breached or not performed as per the condition laid down in the contract, then the other party has the right to sue the other party to make the contract work or otherwise call for compensation for the breach of contract. Now, the way the Indian Contract Act 1872 provides for breach of contract and compensation for such breach of contract, it calls for the applicability of the maxim actio non datur non damnificata. Also, in the cases of Specific Relief Act 1963, a person under Section 5 and Section 7 of the Act 1963 who is entitled to sue the other party and ask for specific performance of the contract. Now, these sections 5 and 7 of the Specific Relief Act also calls for the applicability of the maxim actio non datur non damnificata. The maxim also finds place in the law of torts. Law of torts deal with wrongful acts and the remedy in form of compensation from the wrongdoer. In general, or in the common parlance, the one who does the tortious acts is the wrongdoer. He is also known as the tortfeasor, and the one who is aggrieved from the wrongful acts of the wrongdoer is called the aggrieved person. In the law of torts also, the right to sue is always imparted on the person who is aggrieved of the tortfeasance by the tortfeasor. But there are certain exceptions also. For example, the maxim res ipsa loquitur calls for the thing speaks itself. It means the wrongdoer himself is the one who has done the wrong, and the right to action will always be in the pockets of the aggrieved person, and there is no need to prove by the aggrieved person that the wrong was done by the wrongdoer. But this was the maxim of res ipsa loquitur. Let's not deal with the maxim res ipsa loquitur. Rather, we will deal with the maxim actio non datur non damnificata and applicability in the law of torts. Let's take an example. In the case of negligence, the one who does the negligent act clearly knows that he is breaching certain part of his duty towards the other person with respect to which that other person has the right. The moment negligence is done, the other person has the right to sue the one who has done the negligent act. Therefore, the maxim finds its applicability in the law of torts also, and allows the aggrieved to sue the tortfeasor. The maxim actio non datur non damnificata also finds its applicability in the personal laws. Now, in India, we have different laws for different religion. We have Hindu Marriage Act, we have Hindu Adoption and Maintenance Act, we have Hindu Guardianship Act, and many other acts which deals with the personal laws of the Hindus. Likewise, we have, for example, Dissolution of Muslim Marriages Act 1939 for the Muslims, amongst all other laws which deal with the Muslim personal laws. Now, the maxim finds its place in the applicability of personal laws too. It imparts the right to sue upon the aggrieved. These laws, being substantive in nature, they create rights upon the parties, and whenever the right is infringed, they create the right to sue on the aggrieved. This means that the right to sue is inherent within the right to create obligations upon the parties as well. For example, under the Hindu Marriage Act, Section 9 creates the right to sue. It provides the aggrieved party to apply by way of petition for the restitution of conjugal rights. Likewise, Section 2 of the Dissolution of Muslim Marriages Act 1939, which says that a married woman under the Muslim law shall be entitled to obtain a decree for dissolution of her marriage on any one of the grounds mentioned under the section itself, is nothing but a substantive right which is created upon the Muslim women along with the right to sue if the grounds of dissolution of marriage is entertained. This is how the maxim actio non datur non damnificata finds place in the personal laws. The maxim actio non datur non damnificata finds place in the criminal laws also. This maxim finds place in the Indian Penal Code also. Now, the Indian Penal Code is a code consisting of all the wrongful acts with respect to which the commission thereof calls for liability of the wrongful person against the state. There are acts causation of which gives the aggrieved the right to take legal action against the wrongdoer. Now, in the Indian Penal Code, the wrong being done by the wrongdoer is a wrong against the society at large. Therefore, the society, the state has the right to take legal action against such a wrongdoer. However, there are certain acts the commission of which does not call for any right to sue. These acts are contained under the term general exceptions, which reads from section 76 to section 106 of the Code 1860. However, with these general exceptions, the maxim actio non datur non damnificata becomes inapplicable. Apart from the substantive laws, the maxim actio non datur non damnificata finds place in the procedural laws too. It applies on the Code of Civil Procedure, it applies on the Code of Criminal Procedure, and the other procedural laws. Now, for example, Section 9 of the Code of Civil Procedure 1908 provides a good example of the applicability of the maxim actio non datur non damnificata. It provides the aggrieved person of the right to file suits in the courts of civil nature unless the cognizance of such action is impliedly or explicitly barred. Similarly, in the criminal procedure laws, the actio non datur non damnificata maxim finds its applicability. However, under the Code of Criminal Procedure 1973, there lies an exception to the maxim actio non datur non damnificata. This can be explained by reading the rights given to the arrested person. The arrested person, who is the wrongdoer himself, has certain rights. He does not have the right to sue the one who has arrested him, but he has the right to know about the reasons of his arrest. He has the right to hire an advocate for his case. So, the applicability of the maxim under the Code of Criminal Procedure, especially when it comes to the rights of arrested person, calls for a double review. Apart from this, the applicability of the maxim actio non datur non damnificata finds place in procedural laws, wherein the right to sue is given to the aggrieved against the wrongdoer. Now, the maxim actio non datur non damnificata finds place in the laws of limitation also. The laws of limitation are nothing but those laws which provides limit to litigation. We all know that laws of limitation in India is an adjective law to the procedural laws. It allows the procedure to be litigated but within limits. So, we can say that the laws of limitation is an adjective law. But under section 27 of the laws of limitation in India, that is section 27 of the Act 1963, creates a substantive right of possession of property for long possession of the property in adverse to the actual owners of the property. Now, even if the person is not the rightful owner of the property, but still if he possesses the property for long duration, he will be entitled to the possession of that property by adverse possession. Now, this section creates a substantive right upon such person, and the right is in the nature of possession of the property, which does not allow any right to sue to the owner of that property against the one who has adversely possessed it, because such an adverse possession will give him the rightful possession of the property from which no right to sue arises. This is how the maxim actio non datur non damnificata acts in duality under section 27 of the Act. At first, it provides a substantive right to the adverse possession of the property to the person who is possessing that property for a long duration, and at the same time it snatches the right from the rightful owners of the property just because the property was possessed for long duration by the one who has adversely possessed it. So this is how the maxim actio non datur non damnificata finds its place in the almost all laws of substantive nature, of procedural nature, which some of which are dealt over here. Hope this video finds its usefulness to you. You can reach me at shrutipande.alsn@gmail.com. You can also follow my Instagram channel lex.shruti. Appreciate your time. Do share, comment and subscribe, as it will give me feedback about the videos. Thank you all.